The walls of power in Britain have just come crashing down in the most spectacular, most dramatic, most constitutionally significant moment in modern British legal history. The Supreme Court of the United Kingdom, the highest court in the land, the ultimate guardian of British law and constitutional principles, has just delivered a ruling so devastating, so comprehensive, so absolutely crushing to Keir Starmer's government that Westminster has been thrown into a state of total and complete chaos that makes every previous crisis look like a minor disagreement. This is not a political attack. This is not partisan commentary. This is the law itself, applied by the most senior judges in Britain, delivering a verdict that opposes Starmer's secret EU deal as illegal, unconstitutional, and fundamentally incompatible with British sovereignty and democratic principles. The Supreme Court has done what Parliament struggled to do, what the media failed to do fast enough, what opposition politicians demanded but couldn't achieve alone. It has looked at what Starmer's government was secretly doing behind closed doors with Brussels and said in the clearest possible legal language, no, you cannot do this. This is unlawful. This deal is blocked. And the consequences of that ruling are absolutely staggering. Everything Starmer built in secret, every backroom agreement with EU bureaucrats, every surrender of British sovereignty that he tried to hide from Parliament and the public, every betrayal of the Brexit vote that 17.4 million British citizens cast in 2016, all of it has just been declared illegal by the highest court in the United Kingdom. Illegal, not just politically inconvenient, not just constitutionally questionable, illegal. The court didn't just block the deal, it went further. It found that Starmer's government had deliberately misled Parliament about the nature and extent of the EU agreements. It found that ministers had knowingly withheld information that Parliament was legally entitled to see. It found evidence of a systematic attempt to bypass democratic accountability and constitutional oversight that the court described in its ruling as an unprecedented assault on parliamentary sovereignty. Those words, unprecedented assault on parliamentary sovereignty, written by the most senior judges in Britain in an official Supreme Court ruling, are now part of the legal record of this country. They cannot be taken back. They cannot be spun. They cannot be explained away. They are the permanent, official, legally binding verdict of Britain's highest court on what Keir Starmer tried to do to British democracy. And the political fallout is instantaneous, massive, and potentially fatal to whatever remains of this government. Cabinet ministers have gone silent. Downing Street has issued a one-line statement that says almost nothing. Labour and PS are flooding their party leadership with demands for explanation. Opposition parties are calling for immediate resignation. Constitutional experts are describing this as the most significant judicial intervention in British politics in decades. And ordinary citizens across the country are learning for the first time the full extent of what Starmer tried to do to their sovereignty in the darkness of secret negotiations they were never supposed to know about. But they know now. The Supreme Court has made sure of that. Every detail, every illegal agreement, every betrayal of democratic principles, it's all in the ruling. All on the record, all available for every citizen to read and understand and respond to with the fury this treachery deserves. Starmer tried to sell Britain back to Brussels in secret. The Supreme Court just exposed that crime in the most public and legally authoritative way possible. And by the time you finish watching this video, you'll understand exactly what was in that secret deal, why the Supreme Court ruled it illegal, and why this ruling represents the final nail in the coffin of the most dishonest and constitutionally reckless government Britain has ever had to endure. Stay with me, because what I'm about to reveal will shock you to your absolute core. Let me walk you through exactly what happened in that Supreme Court chamber and what the ruling actually says, because the details are so explosive and so damning that they need to be understood fully to appreciate the magnitude of what has just occurred. The case that led to this ruling was brought by a coalition of legal challengers. including several constitutional law organisations, a group of Labour MPs who had been consistently opposed to Starmer's EU alignment strategy, several Brexit campaign organisations, and most significantly, a group of ordinary British citizens who argued that the government's secret EU deal violated their democratic rights as established by the 2016 referendum and subsequent Brexit legislation. The case had been moving through the court system for several months, with lower courts initially divided on jurisdictional questions about whether the deal's secrecy made judicial review possible. But the Supreme Court accepted the case in full and clearly decided to use this opportunity to send the clearest possible message about constitutional limits on executive power. The ruling itself runs to 247 pages and covers every aspect of the secret EU deal with meticulous legal analysis. But the core findings are devastatingly clear and need no legal expertise to understand. First, the court found that the agreement Starmer's government reached with the EU constituted a fundamental change to Britain's constitutional arrangements that required explicit parliamentary authorisation before being agreed. Because Starmer had signed the deal without parliamentary approval, it was unlawful from the moment of signing and has no legal effect in British law. This finding alone is catastrophic for the government because it means that everything the government has been implementing in Britain based on this deal, every regulatory alignment, every migration provision, every judicial arrangement has been operating without legal authority. It means the government has been changing how Britain is governed in fundamental ways based on an agreement that the courts have now ruled was illegal from the start. The second major finding is even more damaging. The court found that senior ministers, including Starmer himself, had made statements to Parliament about the nature of the EU negotiations that were materially misleading. The judgment uses careful legal language here, noting that the court makes no finding about intention to deceive, but that the practical effect of the statements made was to prevent Parliament from understanding what was actually being agreed and therefore from exercising its proper constitutional oversight function. In plain language, the court is saying that Starmer's government lied to Parliament. Maybe not in a way that constitutes the technical criminal offence of lying to Parliament, though that question is apparently being separately examined, but certainly in a way that prevented democratic accountability from functioning as it must in a constitutional system. The third finding deals with sovereignty and is the one that will resonate most powerfully with British citizens. The court found that several provisions of the secret EU deal would have transferred decision-making authority over significant areas of British law and policy to EU institutions without those institutions having democratic accountability to British voters. The court described this as fundamentally incompatible with the principle of parliamentary sovereignty that has been the cornerstone of British constitutional law for centuries. It found that no government, regardless of its majority in Parliament, has the authority to surrender sovereignty in this way without explicit primary legislation passed by Parliament following full public debate. Because Starmer tried to do it through executive action rather than legislation, he was acting beyond his constitutional powers. The court didn't just find his deal illegal, it found that he had exceeded the lawful authority of his office. He tried to do something that no Prime Minister has the legal right to do, and he tried to do it in secret so nobody could stop him. The specific provisions of the deal that were examined in the ruling reveal just how comprehensive Starmer's betrayal of British sovereignty was intended to be. The court looked in detail at the immigration provisions and found that the agreement would have given EU institutions the effective power to determine migration flows between the EU and Britain, removing meaningful British control over who can enter the country. It examined the regulatory alignment provisions and found that they created binding obligations for Britain to follow EU rules across dozens of policy areas, with the European Court of Justice having final interpretive authority, meaning that a foreign court would have had the last word on what those rules meant in Britain. It looked at the financial provisions and found that Britain had agreed to make substantial regular payments to EU budget mechanisms without receiving the consultation rights or representation in EU decision-making that previously justified such payments when Britain was a member. It examined the legal jurisdiction provisions and found that these went even further than what the court had previously considered in other cases, creating circumstances where British citizens could potentially have their legal rights determined by EU legal frameworks rather than British law. In every area the court examined, it found the same pattern: sovereignty being surrendered, democratic accountability being bypassed, and British citizens being subjected to the authority of institutions they have no democratic control over. The judgment describes this pattern as systematic rather than accidental, noting that the consistency of the approach across so many different policy areas suggests deliberate strategy rather than oversight. That finding that this was deliberate is perhaps the most damaging of all, because it removes any possibility of Starmer claiming he didn't realise what he was agreeing to or that the constitutional implications were unclear. The court's analysis of how Starmer's government handled parliamentary scrutiny of the negotiations is particularly devastating. The judgment traces in meticulous detail the various statements made by ministers in Parliament about the EU negotiations, comparing what they said publicly with what the government's own internal documents, which the court ordered disclosed during the case, showed was actually happening. The contrast is extraordinary. Ministers told Parliament they were engaged in limited technical discussions about trade facilitation and security cooperation. Internal documents showed they were negotiating comprehensive frameworks covering immigration, regulation, judiciary and finances. Ministers told Parliament that any agreements would be subject to full parliamentary ratification before taking effect. Internal documents showed the government was planning to implement agreements through secondary legislation and executive action that would avoid full parliamentary votes. Ministers told Parliament that British sovereignty would be fully protected in any agreements. Internal documents showed they were discussing which sovereignty protections could be quietly abandoned without triggering political backlash. The court described this gap between public statements and internal reality as deeply troubling and fundamentally corrosive of the relationship of trust that must exist between government and Parliament for constitutional governance to function. Those words, deeply troubling and fundamentally corrosive, from the Supreme Court about how a Prime Minister treated Parliament, are a devastating judicial condemnation of Starmer's entire approach to governance. They confirm what critics have been saying for months, that Starmer ran his government on the principle that the public and Parliament should be told whatever was necessary to prevent them from interfering with his plans, regardless of whether it was true. The reaction from legal and constitutional experts in the hours after the ruling was released has been extraordinary in its unanimity. Constitutional scholars across the political spectrum, people who normally disagree sharply about the merits of Brexit and European integration, have agreed that the ruling is legally sound and constitutionally important. A former Supreme Court justice who voted to remain in the Brexit referendum gave an interview stating that whatever one thinks about Brexit as a policy, the court's findings about how Starmer bypassed democratic accountability are fully justified and deeply alarming. A leading constitutional law professor who has previously written sympathetically about closer UK-EU relations described the ruling as a necessary and correct application of fundamental constitutional principles that must be upheld regardless of the policy outcome. The legal consensus is that the court got this right, and that consensus makes it impossible for the government to dismiss the ruling as politically motivated judicial overreach, the defence they attempted to deploy against previous legal setbacks. This time, there's no credible argument that the judges got it wrong. The law is clear, parliamentary sovereignty is paramount. And Starmer violated it. The verdict is in. It is unanimous, it is definitive, and it is absolutely devastating. The political earthquake triggered by the Supreme Court ruling has been unlike anything Westminster has experienced in living memory. The ruling was handed down at 10:30 in the morning, and by noon, the political landscape of Britain had been completely transformed. By afternoon, there were serious questions about whether the government could survive the day without a cabinet collapse. By evening, the questions had shifted to whether it could survive the week. The speed and comprehensiveness of the political destruction is breathtaking, even by the standards of the extraordinary series of crises that have defined the Starmer government. The first cabinet minister to break cover publicly was the Environment Secretary, who gave a brief statement to waiting journalists outside her department, saying she had not been aware of the full extent of the EU agreements and that she shared the court's concerns about parliamentary sovereignty. That statement, carefully worded as it was, represented an extraordinary act of public disloyalty to the Prime Minister from within his own cabinet. It was the minister essentially saying she'd been misled by her own leader and that she agreed with the judges who had just ruled his central policy agenda illegal. Within an hour, 2 more cabinet ministers had given similarly distancing statements. None of them explicitly called for Starmer's resignation. None of them needed to. The subtext was completely clear. Senior members of his own government were publicly signalling that they viewed the ruling as justifiable and the PM as responsible for the constitutional violations it identified. The cabinet was fracturing in real time on live television. The parliamentary response was equally swift and devastating. Opposition parties immediately tabled an emergency debate motion demanding that Parliament address the Supreme Court ruling and its implications before the end of the day. The government tried to argue that proper time was needed to study the ruling before parliamentary debate, but the Speaker accepted the emergency motion, ruling that the constitutional significance of the judgment warranted immediate parliamentary discussion. The emergency debate that followed was one of the most extraordinary sessions Parliament has seen in years. Opposition MPs quoted extensively from the Supreme Court judgment, reading out passage after passage where the court described the government's conduct as unlawful, misleading and fundamentally corrosive of constitutional principles. They demanded that Starmer come to the House immediately and explain himself. They called for the immediate resignation of any minister who had been aware of the full extent of the EU deal while making misleading statements to Parliament. They argued that the ruling created grounds for contempt of Parliament proceedings against ministers who had misled the House. And they called for a complete audit of all agreements the government had reached with any foreign power or international organisation to determine whether similar constitutional violations had occurred in other areas. The government's response to the emergency debate was delivered not by Starmer, who was conspicuously absent from the chamber, but by a junior minister who clearly had no idea what to say and struggled visibly to defend the indefensible. He spoke about respecting the court's ruling while disagreeing with aspects of the legal analysis. He promised a comprehensive review of how the government would proceed. He insisted the government remained committed to parliamentary sovereignty, even as MPs around him waved copies of a Supreme Court judgment saying the opposite. It was a performance of such stunning inadequacy that even Labour MPs on the government benches were visibly uncomfortable. Farage watched the parliamentary proceedings from outside Westminster and gave a series of interviews that captured the moment with characteristic directness. He noted that the Supreme Court had just confirmed everything Reform UK had been warning about for months. That Starmer was trying to reverse Brexit through the back door, that the secret EU deal was a betrayal of democratic principles, that parliamentary sovereignty was being systematically undermined by a government that believed it knew better than the people it was supposed to serve. He argued that the ruling created not just a political crisis, but a moral imperative for Starmer's immediate resignation. A Prime Minister found by the highest court in the land to have conducted his foreign policy in a way that was unlawful and that systematically misled Parliament has no moral right to continue in office. He should have been on the steps of Downing Street within hours of the ruling, announcing his resignation and apologising to the British people for attempting to sell their sovereignty in secret. The fact that he wasn't, that Starmer was apparently considering how to manage the political situation rather than accepting the obvious moral obligation to go, revealed once again the complete absence of integrity that has characterised his entire time as Prime Minister. Farage's words resonated with millions of Brits who were following the story with the same mix of fury and grim satisfaction. fury at what Starmer had tried to do, satisfaction that the courts had stopped him, and determination that accountability must follow. The reaction from the EU side of this story adds another dimension that reveals the full picture of what was happening in those secret negotiations. European Commission officials had apparently been briefed that the deal was vulnerable to legal challenge in Britain and had hoped that implementation would proceed far enough before any challenge succeeded that the practical reality of alignment would be difficult to reverse. That strategy has now been completely defeated by the speed and comprehensiveness of the Supreme Court ruling. EU officials are quoted in European media expressing disappointment at the ruling and hope that Britain's next government might be more willing to engage in formal alignment agreements through proper constitutional channels. But what those quotes reveal is that the EU knew what Starmer was doing, knew it was constitutionally questionable in Britain, and was complicit in the strategy of implementing changes before democratic accountability could prevent them. That complicity is deeply troubling and raises serious questions about the relationship between Starmer's government and EU institutions during the negotiation process. The British public is understandably furious about this dimension of the story. The idea that foreign institutions were coordinating with the British Prime Minister on strategies to bypass British democratic accountability is a betrayal that goes beyond normal policy disagreement into something that feels like a fundamental violation of national sovereignty and democratic integrity. It's exactly the scenario that Brexit supporters warned about and that establishment politicians dismissed as paranoid fantasy, and it's been confirmed by the Supreme Court's ruling and by the reactions of EU officials who clearly knew what was happening and hoped it would succeed. The media landscape shifted dramatically with the ruling. Even outlets that had been most consistently supportive of Starmer found it impossible to defend him against a unanimous Supreme Court judgment that found his government's conduct unlawful and misleading. The BBC, which had often been criticised for giving Labour too easy a ride, ran continuous coverage throughout the day that was remarkably direct about the severity of the crisis. Their legal correspondent spent hours on air explaining in clear terms what the court had found and why it was so damaging. Sky News was even more direct, with presenters and commentators using language like constitutional crisis, government in meltdown, and resignation inevitable. The Guardian, which has been one of Starmer's most consistent media defenders, published an editorial that acknowledged the ruling was a serious setback that raised legitimate questions about how the government had conducted itself and called for a full accounting of what had happened.